wherein we are going to deliberate upon the implementation of the resolutions. The topic is steering corporate debtor out of the abyss. So, the moderator for the session, Anjali Madam, and the panelists, Anish Nanavati ji, C. Ramachandra Rao ji, and Venkat Chalam Varanasi ji. So Anjali Madam doesn't require any introductions. She is our own immediate past chairperson of the Ahmedabad branch. So I won't be sparing a single minute because we want to utilize the time for this conference. So Anjali ma'am, I'll keep your introduction to the shortest possible. And so we have got the three panelists. Mr. Anish Nanavati, who is a practicing insolvency professional, a banker, and he's quite a famous personality within the insolvency framework because he has been instrumental in resolving three corporate debtors: Reliance Communication Infrastructure Limited, Reliance Infratrail Limited, and Reliance Telecom Limited, apart from other matters. So thank you so much, Anish ji, for sparing your time. And may I request Anjali ma'am just to felicitate sir. And I also welcome Sunit ji. Please join hands in felicitation. Welcome, sir. Then we have got Venkat Chalam Varanasi ji. He is a qualified company secretary, a cost accountant, and a law graduate, and also MBA finance. Quite a versatile personality, having more than 25 years experience. He has handled United Seamless Tabular Private Limited and signed Varda Power Generation Limited as a successful resolution. Welcome, sir. And now we have C. Ramachandra Rao ji, a law graduate, also a banker, who has been part of critical accounts like Reed & Taylor, Deccan Chronicle, amongst Kingfisher, and now he is part of the IBBI, and he is legal affair divisions of IBBI. Welcome, sir. And yeah, ma'am, session is all yours, please.
Thank you, CA Jigar Bhatt. Before we start the second last session, let's break the ice. And I would request all of you, including myself, to get up and clap for at least 10 times so that we all can wake up and listen to the last two sessions. 10 times. And the last benchers can come ahead so that you can closely look at the faculties and have interaction. Thank you, all of you. We have an esteemed panelist here. So we would be discussing the implementation of the resolution plan from the RP angle. We are glad to have a regulator also. So guys, stay with me. We are going to complete it in an amazing 40-45 minutes, and we are going to have a great discussion. I hope this clapping serves as an ice-breaking for all of you. And please keep your mobile aside, because many times we are not able to focus on both the sides. So let's start the discussion. Moving first with the Anish ji. Anish ji, you have handled RRR. Reliance Telecom, Reliance Infratel, and Reliance Communication Infra. All three cases, the plans were approved. So before going into the specifics of implementation, I would request you to share your broad thoughts on the aspect and how important a resolution plan implementation is.
Thank you very much. Thank you for this opportunity. And certainly, going to your question, it's actually 4 hours. It's not 3. Reliance Communication, which is the listed entity, widely held, that was the first one. And all the other 3 that you mentioned are subsidiaries of this. Out of the 4, 2 have been resolved, and 2 are still in CIRP. And this is probably the AGM I'm going to conduct is going to be my 6th AGM in this company. Now that said, from a resolution perspective, see, implementation, you should, if you imagine resolution as an arrow, implementation is actually the arrowhead. Okay, it's where the actually the effectiveness would come into. So, and taking into account this implementation, the importance of it, you can look at it in two ways. One is, of course, at the asset level or a CD level, and of course, at the broader macro level. At the asset level, you are anyway resolving the asset. You're getting the capital which was blocked earlier back into the system. So, to that extent, it's beneficial. Second, from a macro level, macro level, we are also looking at it when a resolution is implemented. It sends a signal to the other economic agents that something is working here. Then the possibility of default by a delinquent promoter or a CD, to that extent is reduced, having looked at successful resolutions. So to that extent, it's a signal to the economic agent. And from a broader economic standpoint, in a Schumpeterian sense, you're anyway looking at recycling of capital. So to that extent, the velocity of money is going up, and the economy as a whole benefits. So this is where the, in a sense, the rubber hitting the road. Implementation is, I would say, the end game and crucial to the entire process, so to speak.
Great, sir. The court now suggests for monitoring committee. I would request you to share your thoughts regarding the need for monitoring committee.
See, monitoring committee, there are a few advantages. What comes to my mind is, if it is a complex case, all the more you will need a monitoring committee where you will get the representatives of the key stakeholders on one platform and see to it that the plan is implemented. That is one. Second, when key stakeholders come to implement the plan, there is focus. So to that extent, the speed of implementation to that extent can be enabled by a monitoring committee. Otherwise, it will go into all separate directions. We don't want that. And third is from a regulatory corporate governance standpoint, it is better that the COC, the resolution applicant, and of course the erstwhile RP or the insolvency professional, all of them who are from their own way have looked at the corporate data, all of them coming together, and they would like to see that everybody gets the deal that they are being promised. So to that extent, all the three eyes are on this corporate data in terms of implementation. So to that extent, the balance of risk which was committed in the plan would actually come about.
Thank you. Moving to Venkatji. I know he has a bad throat, but he's super excited to share his thoughts. Sir, what are your views regarding the shift in role from RP to an implementer or monitoring agent?
Am I audible?
Yes.
Yeah. Sorry. Before I get into the main subject, the question which you asked, last time I thanked Sunit Shah for inviting me to Ahmedabad, because this is the place where I learned my first sentence in Gujarati. Okay? Now, the second sentence which I learned, just to be on the lighter vein, I went to a barber shop. I wanted to show off my skills of Gujarati, that I can read Gujarati. I proudly announced, Judwar Jand hai. Can you make out what is wrong in it? No, what I'm saying, when I went to a barber shop, I read the two sentences saying, Judwar Jand hai. Then somebody said, Arey pagal, it's not Judwar Jand hai, Budwar Band hai. Okay. So anyway, I am always happy to come to Ahmedabad. I am grateful that the ISVB and ICAI, WRC, as, can you hear me? No? Yeah. So before even you answer your question, I want to say that an RP is basically a manager. He has been appointed by NCLT for managing the affairs of a company. So as a manager, we all have students of management read about Henry Foyle and F.W. Taylor, who have initiated the principles of management. And the principles of the management can be coined as Plor di Coco or Post-Cop. Planning, organizing, directing, controlling, and coordinating. Now this implementation process is coordinating and controlling process of a resolution professional. Since he is the manager who has been managing the affairs, who has been there throughout the CRP process, he is the apt and adept person to continue as a implementing agency or as a monitoring agency. So that is his role. So it comes natural to him, and all the stakeholders will accept him than anybody else. So he's the right person.
Great, sir. Can you share which are the core issues which an IP confronts during the implementation of plan?
Yeah, see, the first issue will always be the cooperation and the assistance from the staff and ex-management. Without their cooperation, the implementation of any plan will become that much difficult. Okay? And the second thing is, second issue would be mostly the litigation aspect during the process of implementation. Like in one of my corporate data where I was implementing, after the plan is approved and before it is implemented, it took more than 1 year for Supreme Court to pass an order on 21st January 2020. It's all because of litigation. So that is another major issue. So one is the staff cooperation, then litigation, and the timelines itself will be one of the impediments. Because if they say within 1 month you have to implement it, and there is a time, the delay also it could be due to litigation.
Okay, so cooperation, litigation, and timeline sum up the issues.
Yeah, 3 main issues.
Yeah. Looking to the wide experience of Anishji, I would request you to share your experience in the monitoring committee of all the 4 R's you mentioned, and what are the learnings you had?
So as far as the 4 R's are concerned, there will be the first learning is from an implementation perspective should be litigation management. So we had a session on the resolution and various issues that we were talking about. All issues that were discussed, I've been required to grapple with at some point or the other during resolution and the implementation. So you're talking about litigation and disputes with customers, with employees, with SEBI, and the market participants, RBI, GST, indirect tax, direct tax, municipal corporations, and tower owners, landlords. Because when you say Reliance Infratel is a company which owns towers, fiber, and rights of way, which is basically used for telecom connectivity. And it's spread all across India, including Northeast, Jammu and Kashmir, and all states. So managing such a big operation itself was another challenge. So during implementation, we had to take into account the fact that the distribution is about to happen, and we need to keep all the market participants and our stakeholders in play while trying to work out the resolution. And as a matter of fact, the resolution has not happened in the manner that we are talking about. So coming to that, so litigation, when we are talking about, litigation was in respect of between two creditors of the COC. So, and that litigation, actually, two of them are still in Supreme Court. And the COC had to force the issue. And Supreme Court has ruled that as long as the resolution applicant is depositing the money in an escrow account, the plan will be construed as implemented. So depending on the outcome of the intercreditor litigation, the distribution is going to happen. So watch this space in that sense.
Absolutely, sir. But sir, I would like you to throw more light as an IP, how we would handle this litigation. Since you have a wide experience, please share some key learnings because most of us are IPs here.
So what I would suggest is, of course, we have to be very vigilant and alert on notices, letters coming in from any of the stakeholders. Be sure to go through this, look at the issues, talk to the concerned people who would know a background of it within the company. Thankfully, in that respect, there were personnel who were having legacy knowledge of many of the issues that we're talking about. But the response to it would be guided by the code and, of course, value maximization and going concern. So to that extent, go through this and be sure to respond. And if you're taking time, respond saying that we are going to respond, but we're taking time. And see to it that from an implementation perspective or even resolution, you are giving or handing over to the resolution applicant a company where issues, even if they're not resolved, at least it is in play. The corporate debtor, the company is in play. It's not that you've given up on a particular issue. And so going back to, this is as far as notice is concerned. In litigations, again, we have to be clear in terms of the cost of, or what is the stakes involved. The cost of litigation, is it going to be more or equivalent to the kind of stakes involved? Then you might as well settle for a letter and keep sending reminders. If it is stakes are high, go in for litigation.
Great. So be vigilant and the trade-off between the cost, whether to go for litigation or not. Yeah. Moving to Venkatesh, you had a unique experience of Supreme Court directed physical handover to SRA in the Maharashtra seamless case. I would like you to share this unique experience with all of us.
Well, this was my first experience. I was appointed in October 2017, okay? And the plan was approved on 21st January 2019. Thereafter, because of litigation, the position could not be handed over. I handed over the position, they got dispossessed, and they pursued litigation at NCLAT, and it matter went till Supreme Court. And Supreme Court on 22nd January 2020 has given a direction to me asking to hand over the position within 4 weeks, within a month's time. So it was a real challenge. And me, and in fact, Badri is also one of my team members, and Mr. Surinana is my advocate. What we could do is, we have taken, as I told you, those gray areas where challenges are there, like, staff and all that. We have to take the workers into confidence, because workers have realized that it is the successful resolution applicant who is duty bound to pay their dues, and not me after the CRP process ended. So we have coordinated with the police authorities and the revenue authorities and ensured that a smooth handing over of position has taken place. Here, what I would like to stress is documentation is very important at each and every stage. Whether you are corresponding with the police authorities, whether you are corresponding with the revenue authorities, whether you are corresponding with the management who is there at the time of this thing. So once the Supreme Court order has been shown, the management also cooperated and they hand over the position. So handing over the assets, because this company stopped production in 2015 and the CRP process started in 2017. So it's quite a time, there's a delay and the assets status is not the same what it was when the CRP process started. So there were quite a bit challenges, but then within 4 weeks' time, we could successfully hand it over.
There's one learning which I would like to pass on. There were a whole lot of ex-employees in these companies who were yet to get their full and final settlement, and that they had lodged a claim. Given the fact that you're talking about quite a run-up in terms of the time taken, often we get threatening letters, that they will commit suicide, and all that, and there'll be a dharna outside outside the campus. My standard response was, in this case, that go to the nearest police station with this and file a police complaint saying that there could be an untoward incident likely to happen. So, so inform the police and see to it that their cooperation is there to prevent any actual suicides happening. But otherwise, we can't do much because we are bound by the code. We'll not be able to service the claim or settle the claim until the actual process goes through. It's a very bad situation to be in for the employee concerned, ex-employee concerned. We can only offer sympathies, but this way at least you got yourself covered in terms of you taking precautions on your own.
See, initially we had a problem with the ex-management during the process of CRP. After that, to see that the employees are paid their full and final wages because they have not retained, we ensured that all the workers, 60 and odd workers, have got their entire amount fully paid. So that also was one of the challenges.
Yeah, so we need to protect the organization, we need to protect ourselves, and as well as the stakeholders of the
Yeah, and in the process of implementation, a criminal case was instituted against me, where I had to run around criminal courts for almost 6 months. Finally, the complainant is withdrawn. That's a different thing.
Great, sir. Sir, we would also like you to share your experience in the resolution of Sai Varda power generation.
Yeah. While it is the problems here is that of the non-cooperation of the staff in the first case, here it was a challenge to handle the subcontractors. The main O&M contractor has appointed 4 major subcontractors whose bills, because unless they do their work, the production cannot continue. And unless the production continues, power generation continues, the resolution applicants will not show interest. So the challenge is a little different. But here in Sai Varda, the total amount was 6,500 crores was the debt exposure, out of which the resolution amount was 650 crores. So it was an initial payment of, upfront payment of 10 crores, 25 crores is to the operational creditors and others, and 635 crores and odd was to be paid on a deferred basis of 8 years. So we had to ensure monetary committee was formed. As you were saying, bigger the debt exposure, more necessary is the responsibility of a monitoring committee. So monitoring committee where SRA, financial creditors and the RP all have to coordinate, work, and and see that it is implemented. So we have to follow it up that the deferred payment also is made properly.
I think RP should be a leader and should have those interpersonals. Talking to you both, I just got a question immediately. How far you believe that, I think I'm fine with that. Yeah. Right, it's okay. No, 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 sir. I think I'm audible. I have a great voice, yes. So, I should not be. It's okay, it's fine. Fine, fine, sir. So, do you think successful resolution relates more to an RP being a leader, taking people along with it, and are there personal qualities much related to the success of the resolution plan? How far do you believe that?
See, ultimately it depends upon the product, whether the factory is sustainable or not. See, in my case, United Seamless, they are manufacturers of drilling pipes for ONGC. So there's a market for it. So obviously, apart from our, efforts of coordinating the whole thing, it is ultimately the market value of the assets which will determine the whole thing. That's what I feel.
See, you have to remember in any insolvency situation, you are entering into a company where the promoter is looking at his own company being in the process of being snatched away. You know, that's a very sad thing for anybody to happen. But at the same time, so, you know, he's a frenemy for you, okay? He's a friend to the extent that you need his cooperation. But at the same time, you know, he's against you. And he'll do everything possible to see that your plan for the company does not succeed. So here, you have to manage this particular bridge in a very, you know, it requires tact and skill. You need to probably put yourself in his shoes, massage his ego, and at the same time, you know, done with, and then baddu karu pade, and you will need to see to it that, you know, you achieve what you have to do.
Thank you, sir. You answered my second question as well. What policy guidelines needs to be brought out. But again, when the full resolution plan is not approved and we are saving the value of the loss of assets, when you talked about parts, I think it will be more challenging and I think more time will be lost there because in that case we have to go in the chronological order that my first part of resolution plan is not done. How can I move with the second and third? I think that seems more challenging rather than accepting the full resolution plan.
I would like to tell one more thing here. Here the discussion paper floated by the Minister of Corporate Affairs on 18th January 2023 stated that suppose there are 2-3 assets and for 2 assets one COC is in favor, another COC is not in favor regarding the fixation of the price or expected value. In that case, and multiple resolution applicants are showing interest in that case to avoid further future litigations among the resolution applicants, although there is no right as such, vested right in them to challenge a resolution, approved resolution applicant, but it lands up in litigation. Ultimately, stay may be given, may not be given. Ultimately, RP is put to inconvenience. RP basically is a fulcrum of the entire process. He has to lead the entire show, whether there is any litigation or not. Ultimately, when the case ends up, then he is fine, he will be relieved with the success story. So here, what I mean to say here is, when there are multiple different properties located at different places, which is viable, which are not viable, and having multiple opinions among the COC, in that case, the discussion paper also discusses about one thing here. If there is if the applicants are much interested in a particular property, that two people wants this only property, then the challenge mechanism should be adopted so that when the challenge mechanism is adopted, then one person would take the property, take the asset through resolution. Another property has been sufficiently given opportunity and he will be barred from raising a litigation before the court. To some extent, this would reduce the time. I mean to say that. Maybe it may not be universally applicable to each and every case. Depends on the facts and situation of the case. But law should be enabled for all the situations.
Thank you, sir. Sir, we would also like to know your thoughts on certain pain points like stamp duty, taxation impact, accounting issue, which exist when SRA initiates implementation. So please share your thoughts on this.
Actually, I would not like to pass on any comment here. This is a typical question in the sense say that the section 30, subsection 2 says that the AA has to ensure that the resolution is compliant with the other laws existing in force, in vogue. So if the other law says which stamp duty pertains to the state law, central government talks about the other tax matter, and some other authority says that I want the dues as payable to the authorities like urban development authorities. So it's one single regulator may not be able to do it, but there was a thought a long time back that if a resolution plan is approved, there should be a single window system whereby one person would be able to take clearance from all the other authorities. Other authorities would be able to coordinate and see that the clearance part is secured at the earliest so that plan could be implemented. This is a far-reaching so far.
Great, sir. Sir, one last question to you, and then the audience can ask one or two questions. Is there any monitoring being done by the regulator to track the progress of implementation?
Not exactly. We are watching the plans once implemented, but in individual cases, as such, there is no monitoring or mechanism. The resolution professionals and the stakeholders keep questioning to us, but the thing is, as such, there is no monitoring system as such, except that the IBBI wants to reduce the litigation part in the implementation of resolution, and they want to reduce the time and ensure that the value maximization is done in a way that the resolution applicants could be able to submit for the varied kind of assets in the market.
Thank you, sir. Now it is open for the audience if they have any questions. Yes, Yashri.
My question to Rao sir. At the time of implementation, we are facing so many issues, perspective regarding the ROC, like the shifting of register office or the company is not active, non-compliant, and filing of various returns and all these things. So can the IBBI or ROC or MCA are coming together and coming with only one forms, and all the entries like in the master data will be the change? Because since last 1 year, so many cases I have, so we are facing the same issues like the active non-compliant and all these things, and implementation process itna proper nahi chal raha iski wajah se.
Yes, yes. You have raised a right question. So MCA is taking up this issue, and one common platform wherein NCLT, ROC, MCA as a whole, IBBI, everybody would be in one part, and one facilitation is being given to everyone, including the professionals, where they will be able to see their case management as well. It's a larger project, but it's in the on. Discussions are on.
Thank you, sir.
Sir, one addition to the same query. In majority of cases, we found that at the time of admission of CRB cases, last 2, 5, 10 years, ROC returns are pending. And practically, management are not providing any data. So as per CA regulations, there is no possibility to conduct the audit of the books of accounts. Even unaudited accounts it is nearly impossible to upload on the GNL2 form in the MCA website. And after approval resolution plan, the at the time of implementation, RAs keep following us to give us the signed balance sheet till the date of approval of resolution plan. And it is nearly impossible. There is no such law or regulations in IBC where the RP have to provide all this data. Even though it is specifically mentioned in the IM that certain books of accounts are not ready or the financial statements are not available. But there are certain case laws where NCLT asks the RP, and there are certain orders of ROC that it is the duty of RP to make the compliance as per the Companies Act, as per Section 18 of Section 17 of IBC code, IBC. So, how the RP should behave in this case?
There is no law, it is no law. If law is not provided to you, and if you are not duty bound, I think you need not comply. But the question you raised is well taken. We have floated one portal wherein the specific issues not pertaining to IBC, but as a part of compliance, kindly raise it. IBBI has raised separate. There is a portal for that. You can raise all your suggestions or suggestions only you can make. Once in a year, we will do it. We will compile it. If there is a need for regulation, we will make it. But I don't think there is a need for making a regulation from IBBI perspective.
If the audit report is not prepared, then how will the company comply for the future? सर अगर ऑडिट रिपोर्ट पुरानी नहीं बनेगी तो आगे जो भी कंपनी को फाइल करनी है, जिसने भी आरए ने ली है, वो कंपनी फाइल कैसे करेगा? उसको स्टार्ट तो करना पड़ेगा कहीं से।
नहीं, ऑडिट करने के लिए, आईएम करने के लिए तो आईएम, व्हेन यू आर कंपेयरिंग द आईएम, यू आर डेफिनेटली प्रिपेयरिंग द बुक्स ऑफ अकाउंट्स।
सर आईएम की बात नहीं हो रही है, आफ्टर रेजोल्यूशन की बात हो रही है। अगर ऑडिट रिपोर्ट ही नहीं बनी है तो बाद में भी कंपनी को कंप्लाई तो करने हैं, अकाउंट्स फाइल करने हैं। अगर ओपनिंग बैलेंसेस नहीं है तो कैरी फॉरवर्ड कैसे होंगे?
नहीं होगा।
तो फिर वो कंपनी कंप्लाई कैसे करेगी, आगे से रिटर्न्स कैसे भरेगी?
I have this problem yesterday because I started an implementation yesterday, and they wanted a statement of assets and liabilities of the company as of the last day of the resolution. So precisely your point, where they will need this for future audit accounts preparation. We can give this with a caveat that this corporate debtor is being handed over on an as is where is basis, no reps and warranties or no indemnity in this regard or any way, and the RP, the COC or the advisors of these parties will not be held accountable for any errors that may occur in this.
Sir, there's also another issue कि जो पुराने रिटर्न्स बाकी होंगे, अगर लॉ उनको एग्जम्पशन नहीं देता है तो वो कैसे फाइल हो सकेंगे?
Yeah.
Sir, I have got experience of 5 registration plans. 4 registration plans I have implemented. Okay. I have been able to handle all ROC compliances. How the ROC compliances works? One basic principle we have to understand. When we come, we have to file a form, which is called Gen 2, correct? Gen 2 essentially would mean they take our signature on the ROC records. Thereafter, we can file all the forms during the CRB period. Once the resolution, once the SRA comes in, we have to file the Gen 2 again. That means the new board has to come into play. Up to here, I'm just explaining how the ROC functions. Now, let's go to the next ROC compliances. Now, when you talk about the ROC compliances, there is a shareholder the share capital changes, there is a board changes, Once the board changes, when the shareholder changes, we generally do through our signature. We file, generally we file, because as a monitoring professional, what happens, generally we just little bit delay it, and then we file it so that from process perspective, it doesn't have any problem. In one of my matter, there was a gap of the balance sheet. So what we did, that there was a gap of 2 years. So we just picked up the opening balances, then we incorporated our transactions, we finished it off that. Of course, that was a disclaimer we have put it on. Next year again we went it, the same thing we did it, we got it approved from the AGM, we uploaded it, documentation is complete. That is the way we have handled it.
IBBI, I just wanted to, just from my side, I just wanted to tell one thing. So as far as the, whenever the resolution applicants fail to implement or when there is a direction from the AAWA, so there is no other go except to go ahead with the penal provisions, section 74, where the central government and the IBBI has been empowered to initiate prosecutions. So there are about 7 prosecutions, complaints filed before the various special courts, I meant to say. Then information.
Thank you, the esteemed panelists and the audience. We really had great learning sessions. And I would request Jigar to...
Yes, thank you so much, sir. So indeed, getting approval of the resolution plan is a milestone event. Equally, getting implemented a resolution plan is another milestone event. And you have thrown a good insights on how best we can do the implementation. And for delegates, the things are complicated so that it's good for us that we can play our part in implementing the resolution plan. So things should be complicated, not very simple. And so thank you so much, Varanasi ji, Anish ji, and Ramchandra ji for giving your all experience insights. And thank you so much, Anjali ma'am, for moderating the session. Thank you.